Hello everyone, my name is Yuan Fu with ID 12111000842. Together with me, we have Yusuf Akram with ID 12213000757, as well as Grace Wong Wei Ting with ID 253UU24248, and Muhammad Shafiq bin Fladi with ID 12011000126, and lastly, Noor Aisha Muhammad Hanif with ID 12213022347, which form the entirety of this group. The purpose of this presentation is to identify and explain the issues that we have identified with regards to the questions provided. So let us begin. So the first issue is whether Aida is entitled to the 10,000 ringgit award advertised by Cepat Sihat Sdn Bhd. So for my first sub-issue, as a general rule, an offer can be made to a specific person or to the world. However, we'll only explain and discuss about an offer that is made to the world, which I will explain why later. A landmark case to illustrate an offer can be made to the world can be seen in the case of Carly was Carblix Football Company. So in this case, the defendant had issued an advertisement to the general public. The advertisement here is held to be an offer because it had become a contract when anybody comes forward and performs the conditions stipulated. Thus, there was an acceptance of the offer by the plaintiff's conduct. So applying back to our question, Cepat Sihat Sdn Bhd had launched a nationwide advertisement showing that the nature of an offer made to the world. So this advertisement also stipulated conditions such as using immunopatch daily for 30 days and still develops severe skin allergy. Thus, there will be a contract when anybody comes forward and performs these conditions that I just stated. All in all, the advertisement made by Cepat Sihat Sdn Bhd was an offer made to the world. Alright, moving on to the second sub-issue. Another general rule that we will be discussing is the fact that an advertisement is generally an invitation to treat, but in some exceptional circumstances, it will be an offer instead. A case to illustrate such general rule can be seen in the case of Kohlhall versus the Public Services Commission, whereby in this case, the appellant had applied for the post of Assistant Passport Officer advertised in a Malaysian newspaper. The court held that such advertisement was merely an invitation to qualified persons, and the subsequent applications were actually the offers, not the advertisement itself. However, such principles does not apply to our question. Why? I'll tell you why after explaining the exceptional circumstances as provided in the case aforementioned, which is the Carblix Smokeball Company case. In this case, the defendant, who was the owner of the Carblix Smokeball, issued an advertisement offering to pay £100 to any person who contracted influenza after using the smokeball in the manner prescribed. The advertisement also stated that the defendant had deposited £1,000 with the bankers to show their sincerity. The plaintiff bought the ball after seeing the advertisement, to which the plaintiff had also used the ball in the manner prescribed. However, the plaintiff unfortunately caught influenza. The court held that the advertisement was only an offer because a contract will be formed once any person stepped forward to perform the conditions stipulated. And the plaintiff here had performed the conditions stipulated by using the smoke ball in the manner prescribed. This case is also an example of an advertisement of unilateral contract, which will be held as an offer. Under unilateral contract, the only outstanding obligation is on the party who has yet to perform their promises. For example, under Khalil's case, the outstanding obligation was on the defendant to pay the £100 as promised after the plaintiff had used the smoke ball in a prescribed manner after the plaintiff had performed their part. Section 8 of the Contracts Act 1950 actually provides that a proposal or offer is considered legally accepted when the offeree fulfills the specified conditions or accepts the consideration provided for a mutual promise. This section reflects. Now, applying back to our question, the advertisement is clearly not an invitation to treat because Cepat Sihat Sdn Bhd was not looking for applications or offers to buy their goods, unlike in Kohlhall's case, where the job advertisement invites people to apply. The offer only happens when the person applies under Kohlhall's case. Instead, Cepat Sihat Sdn Bhd is promising a specific result to anyone who performs the conditions, thus making Kohlhall's case inapplicable, but Carlos case applicable instead because Aida has performed the conditions stipulated by Cepat Sihat Sdn Bhd. The scenario also reflects a unilateral contract under Section 8 of Contracts Act because Cepat Sihat's offer is accepted when Aida fulfills the conditions stipulated. However, the Cepat Sihat could argue that if the advertisement were an offer, they would be liable for an infinite number of claims, even if they lack the funds or stock to fulfill them. Lastly, in order to establish a valid contract, there needs to be the existence of intention to create legal relations. In NM Ruha Majumdar against R.E. Dano, the court held that house viewings and casual discussions following an advertisement did not create a binding contract. Without a signed agreement, such informal interactions are insufficient to prove a clear intention to enter into a legal relationship. Meanwhile, in the case of Carly's Smokeball Company, once again, the intention to create create legal relations can be seen through the defendant's action when they deposited £1,000 with the banker to show their sincerity. Applying back to our question, the intention to create legal relations can be seen through Cepat Sihat's conduct when the company deposited money into June Bank to prove their sincerity, just like Carleo's case. Cepat Sihat had moved the advertisement out of the realm of promotional gimmick into the realm of a legally binding offer. The relationship between Cepat Sihat and Aida was also not casual, unlike in the case of Majumder. The terms were fixed and required only performance by Aida, making it a binding offer rather than a casual conversation. Thus, there was an intention to create legal relations by Cepat Sihat Sdn Bhd. However, Cepat Sihat could argue that the relationship was too remote to infer a legal relationship without a signed document between the company and Aida. In Leonard against PepsiCo, for example, the court ruled that PepsiCo did not have an intention to create legal relations when it featured a Harrier fighter jet on a TV commercial, as no reasonable person could have believed the offer was serious. The advertisement was considered mere puffery or a joke, not a valid offer that could form a binding contract. Cepat Sihat could argue using this case that no reasonable company would have seriously promised to pay 10,000 ringgit to every person who gets a rash, and that the ad was mere puffery similar to the jet in Leonardo against PepsiCo case. In conclusion, the advertisement by Cepat Sihat Sdn Bhd is a unilateral offer made to the world rather than a mere invitation to treat, and there was also an intention to create legal relations as evidenced by Cepat Sihat's conduct. Therefore, Aida is entitled to the 10,000 ringgit award advertised by Cepat Sihat Sdn Bhd. We advise the company to settle the claim. Continuing to label the ad as a gimmick despite the June Bank deposit is legally indefensible and may cause further reputational damage. In the future, they must avoid sincerity deposits and use clear invitation to treat language if they do not wish to be bound by such rewards.
The issue is whether Hafiz and Aida, as the third-party beneficiaries to an agreement between Rahman and Johan, have the locus standi, which is the legal standing to enforce the contract and claim the 15,000 ringgit Malaysia from Johan estate. Under the common law position of the doctrine of privity, this doctrine highlighted that the contract is a private relationship between the parties who made it. Consequently, a contract cannot confer rights or impose obligations of any person who is not a party or part of the agreement. This principle can be seen in the landmark case of Tweddle and Atkinson in 1861. In Tweddle, the fathers of a bride and a groom entered into a written agreement promising to pay a sum of money to the groom for the couple's maintenance. When the bride's father passed away without fulfilling his promise, the groom sued for the executor of the estate, Atkinson, to recover the money. However, the court held that the groom's claims has failed. The judge reasoned that the groom was a stranger to the contract and a stranger to the consideration, even though the fathers had specifically intended for the contract to benefit him. He had no legal right to sue because he was not a party of the exchange of the agreement. The significance of the Tweddle and Atkinson cases cannot be overstated. It established that under the common law, the interests of a third-party beneficiary are legally irrelevant if they lack of a contractual privity. Therefore, according to these rules, Hafiz and Aida would be barred from recovery because the legal relationship existed only between Rahman and Johan. Now, let's look into the Malaysia legal position and the precedent of Kepong Prospecting to the specific facts of Aida and Hafiz claim. Under Section 2, Subsection D of the Contract Act 1950, it states that consideration exists when, at the desire of the promiser, to the promisee or any other person has performed an act. Hafiz and Aida marriage has technically provided a valid consideration under Malaysia law for Section 2, Subsection D of the Contract Act. However, the application of the law has not been fulfilled yet. It was established in Kepong Prospecting Limited and Schmidt 1968, which treated a similar situation. In that case, even though it was acknowledged that Schmidt had provided services that could count as consideration, he is not entitled to enforce the contract because he was not a party to the written agreement between the company and the permit holder. Applying this to our case, Hafiz and Aida find themselves in the same position as Schmidt. While their marriage served as a valid consideration at the desire of their fathers, it does not grant them to be part of the contract. They were intended to be the beneficiaries of the promisee, but they were not the contracting parties of the contract. Applying these rules to the current situation, the contract was formed strictly between Rahman and Johan as close friends. Although the agreement intended it was to benefit Hafiz and Aida, they were not parties to the contract. Hafiz and Aida are strangers to the contract. Their marriage was the condition of the promise, but it did not grant them the parties of the contract. Furthermore, we must examine if there are any exceptions that apply. The exception of trust does not apply because there is no evidence showing that Johan intended to create a formal legal trust. It was a mere personal promise. And the exception under the agency This exception is also inapplicable as Rahman acted in his personal capacity as a father, not as a legal agent for the couple. In conclusion, Hafiz and Aida are not entitled to claim the 15,000 ringgit Malaysia from Johan estate. The doctrine of PPT of contract, as applied in Twitter and Atkinson and upheld in Malaysia through the case of Kapong Prospecting Limited, prevents that a third-party beneficiaries from enforcing a contract that they did not enter. Since no legal exceptions are applied to this domestic arrangement, the executor of Johan's estate is legally justified in refusing the payments.
Greetings everyone, my name is Grace Wong Wei and my student ID is 253UU2424H. And today I will be presenting the third issue, which is whether the promise made by Aida's mother to provide a monthly allowance of 2,000 ringgit while Aida pursued her law studies constitutes a legally binding contract, or whether it is merely a domestic arrangement lacking intention to create a legal relation. The intention to create a legal relation is an essential element of a valid contract. In domestic or family agreements, there is a rebuttable presumption that the parties do not intend legal consequences, as such arrangements are generally based on mutual trust and affection rather than a legal enforceability. Now let's see a few relevant case law that is related to the facts. The leading authority is the Balfour and Balfour 1919, where an agreement between spouses for maintenance was held unenforceable as it was a family arrangement. Similarly, in the case of Jones and Padavaton 1969, a mother's promise to financially support her daughter's legal studies was held not to create a legal relation, despite the daughter acting upon the promise. However, this presumption may be rebutted where circumstances indicate a clear intention to be legally bound. For example, in the case of Married and Unmarried, 1970, an agreement between estranged spouses reduced into writing was held to be legally binding. Likewise, in Simpkins and Pace, 1955, a domestic arrangement involving regular financial contribution and shared expectation was enforceable due to the presence of mutual obligation. In the present case, Aida accepted her mother's offer to leave her job and study law full-time in return for a monthly allowance. Although Aida relied on this promise and altered her position, reliance alone is insufficient to establish legal intention in domestic arrangements. The facts closely resemble Jones and Padavaton, where financial support for education within a parent-child relationship was held to be non-contractual. There is no evidence that the arrangement was formalized, reduced into writing, or made in circumstances indicating legal consequences were contemplated. Furthermore, the relationship was initially harmonious, unlike Married and Married, and there was no mutual financial contribution as in Simpkins and Pace. The mother's assertion that family arrangements are in contracts further supports the absence of intention to create a legal relation. In conclusion, it is likely that the presumption against legal intention in family arrangements applies and has not been rebutted. Accordingly, the arrangement between Aida and her mother is not legally enforceable, and Aida is unlikely to succeed in claiming the unpaid allowance. That is all from me. Thank you.
Good day, madam. My name is Muhammad Shafiq, and now I shall proceed with the fourth issue. Now, the fourth issue is whether the scholarship's term demanding Aida to pay the entire bond amount is unfair and constituted a penalty after she have breached the 5-year government scholarship bond as she resigned 2 years later to work overseas. Before the passing of the Contracts Amendment Act 1976, we can refer to the case of Government of Malaysia and Thelma Fernandez in another, whereby the facts of this case is somewhat similar to Aida's circumstance. The facts, according to the facts, the scholar was provided scholarship to train at the Malayan Teachers Training College, and the scholar was bonded to serve as a teacher for 5 years. However, the scholar breached the scholarship agreement as the scholar itself served for 2.5 years only. So the government seek to claim all the monies that had been expended for the scholar's studies. On the other hand, the scholar alleged that the said provision is considered as a penalty and therefore it is not refundable. However, according to Judge Raja Aslan Shah, it was held that the government is entitled to recover all the monies, and the refund is not considered as extravagant or considered as a penalty. compared to the far greater loss that the plaintiff might actually suffer, as they would lose a qualified teacher and the time factor to train another one. So therefore, the scholar was made to repay the government the total sum used on his education. Moving on, after the passing of the Contracts Amendment Act 1976, we can actually apply to the Section 5 of the Act itself, whereby it provides remedies in the event of breach by the scholar. There are two circumstances. Firstly, Section 5A is applicable when there is a fixed sum stated in the agreement. The scholar will be liable for the whole sum stated in the agreement, regardless of whether there is an actual damage caused or the scholar had partially performed his contract. Secondly, Section 5B is applicable when there is no sum mentioned as payable in the event of breach. So, this section will be applicable when there is a clause providing that the whole of the sum spent on the scholar is payable. However, it is not stated in the agreement. Now, applying to the facts, it is clear that Aida has breached the 5-year government scholarship bond after serving the Ministry of Health for 2 years and resigned to work overseas. So, the government's demand and the agreement's term whereby Aida needs to repay the entire bond amount is actually considered fair and not a penalty, which has been held in the case of Thelma Fernandez's case and allowed by the Contracts Amendment Act itself. So, in conclusion, from the government's perspective, the demand to repay the entire bond is actually not unfair or considered as a penalty, and therefore they can actually sue Aida and claim for damages to make Aida repay the entire bond amount due to the breach of the scholarship agreement. So now, what can Aida actually do in this situation? So the issue here will be whether Aida can reduce the amount of damages since she had served for 2 years with the Ministry of Health. We can refer to the case of Government of Malaysia against Gurcharan Singh and others, whereby the government sued the defendant for breach of agreement, claiming for 11,000, which is alleged to be the total sum spent by the government for educating the first defendant. However, the defendant pleaded that they had served the government for 3 years and 10 months out of the contractual period of 5 years. The claim for 11,000 is deemed excessive and not a reasonable compensation. So in this case, it was held that the government could not claim the total sum of 11,000, but instead it must be based on the repayment of the proportion of the actual sum expended based on the completed months of service. So in this case, the defendant had to pay only 2,683,000. So applying to the facts, Aida had served for 2 years before she breached the scholarship agreement. So as per the Gurcharan Singh's case, instead of the repayment of the entire bond amount, Aida can actually argue that she should only pay the remaining 3 years of service which she did not complete. So in conclusion, in Aida's perspective, she may argue that and rely on the Gurcharan Singh's case, whereby the amount of damages should be based on the remaining service that she did not complete with the government. So that is all for me. I shall now pass on to the next person to discuss on the 5th issue. Thank you.
My name is Nur Aisha, so I'll be explaining the 5th issue. So the 5th issue is whether Aida, after making a counter offer of 450,000, can subsequently accept Laila's original offer of 500,000 for the house in Seremban. For this issue, I refer to 4 sections of Contract Act 1950. So the first section is Section 2A, which defines a proposal or offer, where it stated that when one person signifies willingness to do or abstain from doing something with a view to obtaining the assent of another. The second section that I refer to is Section 2B, which defines acceptance. In this section, it stated that when the person to whom the proposal is made signifies assent, the proposal is accepted. The third section that I refer to is Section 7A, where it stated that acceptance must be absolute and unqualified. And last but not least, I refer to Section 7B, which is stated that a conditional acceptance or one with variations amount to a counteroffer and not acceptance. Together, this provision established that acceptance must mirror the terms of the offer, and any variation of counter-proposal extinguishes the original offer. So for this issue, I refer to the case of Hyde and Ranch. So in this case, the defendant offered offered to sell his farm for 1,000 and the plaintiff has counter-offered for 950 and the defendant rejected this. Later, the plaintiff tried to accept the original 1,000 offer and the court held that the counter-offer has destroyed the original offer because once rejected, the original offer could not be revived unless it's renewed. And the principle is a counter-offer amounts to rejection, so meaning the original offers cannot later be accepted. Next, I also refer to the case of Jones and Daniel, where in this case, the defendant had offered to sell the land, and the plaintiff purported to accept but introduce new terms in a draft agreement. The court held that this was not acceptance but a counter-offer, and since the defendant never accepted the new terms, no contract was formed. In this case, the principle is that acceptance must be absolute, and any alteration or addition amounts to a counter-offer. I also referred to the case of Stevenson and McLean. So in this case, the defendant had offered to sell iron, and the plaintiff had asked whether the delivery could be staggered, and the defendant treated this as rejection and sold elsewhere. The court held that the plaintiff's query was only a request for information and not a counter-offer. The original offer remained open, so the principle of this case is the distinguishes between a counter-offer, which kills the offer, and a request for information, which does not. Next, I also refer to the case of Malayan Flour Mills and Saw Ng Chi, where in this case, the dispute concerned whether acceptance of contractual terms was absolute or whether variations amounted to counter-offers. It was held that the court affirmed that the acceptance must be unconditional and any variation amounts to a counter-offer. The principle was Malaysian courts adopt the English common law principle that counter-offers extinguish original offers. To apply, Section 2A defines a proposal or offer as when one person signifies willingness to do something with a view to obtaining the assent of another. So in this case, Laila's statement offering to sell the house for 500,000 was a valid proposal. Section 2B defines acceptance as when the person to whom the proposal is made signifies assent. So for a binding contract to arise, Ida must have signified her assent to Laila's proposal, but instead of assenting, she replied with 450,000. Section 7A requires that acceptance must be absolute and unqualified. Since Ida replied varied the terms of the original proposal, it was not absolute acceptance. Last but not least, to apply Section 7B, it makes it clear that a conditional acceptance or one with variation amount to a counter-offer, not acceptance. By proposing 450,000, Ida made a counter-offer which legally rejected and extinguished Laila's 500,000 proposal. This principle is well established in the case law that I will be explaining next. Applying to the case laws, in the case of Higham Ranch, where I mentioned earlier, the defendant offered to sell his farm for 100,000 and the plaintiff counter-offer for 950, and the court held that the counter-offer had destroyed the original offer and left nothing to accept. The same reasoning applies here, where Ida 450,000 counter-offer destroyed Laila's 500,000 offer. Similarly, in the case of Jones and Daniel, the defendant offered to sell land and the plaintiff purported to accept but introduce new terms in a draft agreement. The court held that this was not acceptance but a counter-offer, and since the defendant never accepted the new terms, no contract was formed. In this case, Ida's 450,000 reply altered the terms of Laila's 500,000 offer and thus amounted to a counter-offer, not acceptance. The distinction between a counter-offer and a mere request for information was clarified in another case that I've mentioned earlier, which is the case of Stevenson and McLean. Distinction between a counter-offer and a mere request for information was clarified in Stevenson and McLean. In that case, the plaintiff had asked whether the delivery could be staggered, and the court held that this was only a request for information and not a counter-offer. If Ida had merely asked, "Would you consider 450?" the 500,000 offer might have remained alive, but she made a firm counter-offer which extinguished the original offer. Closer to home, the Malaysian case of Malayan Flour Mills and Saw Ng Chi reaffirmed that acceptance must be unconditional and any variation amounts to a counter-offer. This confirmed that Malaysian courts adopt the English common law principle that counter-offers extinguish original offers. Applying this principle, it is clear that Ida's 450,000 counter-offer legally rejected and extinguished Laila's 500,000 proposal. When Laila So in conclusion, applying this principle, it is clear that Aida's 450,000 counteroffer legally rejected and extinguished Laila's 500,000 proposal. When Aida later attempted to accept 500,000, this was not acceptance of an existing offer but a new proposal. Laila was free to reject it and she did. In conclusion, Aida cannot accept Laila's original 500,000 offer after making a counteroffer of 450,000. The counteroffer destroyed the original offer and her subsequent attempt amounted to a new proposal, which Laila was under no obligation to accept. Therefore, no binding contract was formed between Aida and Laila. Thank you.